Thank you, Mr. Chair. On behalf of the Green Party, I want to address Clause 4 about the claim of right, which is one that seriously concerns us. It seems that the amendment to the Crimes Act is motivated by the Crown losing a particular case, sometimes known as the Waihopai 3, where the defendants used claim of right, sometimes called colour of right, as a defence. Presently, in the Crimes Act, claim of right is defined as, in relation to any act, means a belief that the act is lawful, although that belief may be based on ignorance or mistake of fact, or any matter of law other than the enactment against which the offence is alleged to have been committed. And the change in the bill before us is to make that word a belief at the time of the act in a proprietary or possessory right in property in relation to which the offence is alleged to be committed. And I think it applies, for example, in its very restricted form to, for example, someone picks up a bag off the belt at the airport, chucks it in the back of their car, drives off, and then all of a sudden they find blue flashing lights behind them, and somebody saw them steal a bag off the belt, and they say, well, look, I must have picked up the wrong bag, it looks very much like mine. And of course they wouldn't get away with it if it had been stolen from, say, a rich-looking tourist and it was a completely different type of bag. But there was a reasonable belief that they thought it was their, if there was a reasonable belief they thought it was their bag, they would get off. So there's an element of reasonableness in this amended law, even though the word reasonableness doesn't appear. And if you look at the law it's narrowing, there's also implicitly, even if not explicitly, and sometimes in colour of right or claim of right laws around the world, they do have an explicit reference to reasonableness in terms of the mistake or belief. But in this case, in both the amended law and the original law, there isn't that reference to reasonableness, but implicitly it is there. And this is true sort of internationally. Another example, which now unfortunately is not covered by the claim of right, is, for example, somebody hears in the house next door yelling and screaming, and it appears that someone is being attacked, and they break down the door and rush in and find that the noise is coming from the television set, and the owner of the house gets very upset and takes them to court for breaking down their door, criminal damage, etc., and they may be able to get off if they thought that they honestly believed that there was some real danger to a person going on inside that house, and they made a genuine mistake. And the Waihopai 3 case was in some ways an extension of that principle, in that in all of the two cases I've mentioned, the first case the person technically might have thieved the bag from the belt. In the case of breaking down the neighbour's door, they maybe technically have committed damage to the door. And in the case of Waihopai, the defendants didn't deny that they'd technically damaged the covering of the satellite dish. The question is, was there some reason, genuine belief, that sort of overrode that technical breach of the law? And in the case of the Waihopai 3, they argued that they were doing it to abide by a larger purpose, a larger law, that is to stop the continuing killing of people by the American government in the illegal war in Iraq. Mr. Chairman?
Keith Locke.
And the jury in that case presumably accepted that argument. Then some of those questions have been challenged in a recent decision by Justice Gendel in the High Court, and this has been covered a bit in the media, where Justice Gendel went back to that case and sort of assessed whether in fact there was reasonableness in what the Waihopai 3 did, and he brought out some very interesting judgment, interesting points, and he said that the defendants hadn't, quote, identified imminent peril or danger to an identified person or persons. And the defendants in the earlier case had argued they weren't specifying people. There was an ongoing war, an illegal war, where hundreds of thousands of people had been indirectly or directly killed, and the whole question of legality of that war related to the legality of what they were doing in damaging the dome at Waihopai. The other element that Justice Gendel brought up was that quote, the legality of a decision by the executive arm of government to go to wars beyond the capacity of the courts. That is, we can't judge something if it's related to something happening in another country by another government, which I don't think was the way that the district court jury had decided it in the Waihopai 3 case. But that raises a whole interesting question of the relationship of New Zealand law to international law. Another point he raised was in terms of, clearly it was an act of protest, but Justice Gendel said it to qualify it had to be an act of rescue, of rescuing particular people. So there's a whole controversial area there of whether the courts can accept that protest might have a good effect in terms of upholding international law, protecting lives in another country. And you could argue, if you look at the whole Arab Spring, that some of the protests there, mass protests, have ended dictatorships that were killing people, imprisoning people, torturing people, and while the protests mightn't have been a direct act of rescue in Justice Gendel's term, they were acts of protest that were helping uphold the law and protect lives. And so there's a whole lot of controversial issues here, which is why I think what Rajan Prasad said in terms of some of the submissions before the Select Committee, that we shouldn't really be rushing to change the Crimes Act provision for claim of right just on the basis of one case. When these issues are very much alive in debate, we should take our time. It isn't as if there's been a whole pile of cases beyond property-related cases using the claim of right. We don't need to rush to change it. So the Green Party is very strongly against changing the law on that basis, and I think it's that whole question of the relationship of domestic law to international law, and the extent to which not only governments can help uphold international law, particularly law relating to aggression, killing of people, genocide, all of these things, that it's not just the governments perhaps that have a role in upholding that international law, but communities and protesters and all kinds of people can engage in a similar exercise. In fact, we've been celebrating the 30th anniversary of the anti-Springbok tour demonstrations, where clearly, by all accounts, including Nelson Mandela's, the protest action then, some of which did technically breach laws, did help end the suffering of black people in particular in South Africa. So, and in one sense, many of the defendants in those anti-Springbok tour cases 30 years ago used a kind of colour of right defence, even if they didn't actually spell it out that way, and were given light sentences or no sentence or community service or whatever for sitting on planes and on motorways and God knows what. I think, even today I think some people were, it might have been Auckland Airport or Wellington Airport, they actually invaded the airport and sat on a plane where you'd be carted off for a major terrorist offence today, but they were given community service because you know, their motives for helping people overseas. Thank you.
Katrina.